Welcome to episode 27 of the Ask the Law Firm Seller Show. My name is Jeremy Poock and I lead Senior Attorney Match. In today's Ask Show, we'll have three segments. We'll start with our Q&A. Today, we're going to welcome in a guest, attorney Greg Maxwell. Greg joins us from Amicus Settlement Structures. Amicus Settlement Planners, excuse me. And we look forward to welcoming Greg to address the following question. Greg's going to address what tax savings value do structured settlements provide to sellers and buyers of contingency fee law firms? And then we'll have our Poock's Post, and our Poock's Post today will address why the time has started to tick on Law Firm Sales 1.0. So let's jump right into it with our first question today. Our first question today is, what is Senior Attorney Match's design phase? So Senior Attorney Match, what we do is we design and broker the sales of law firms. In the design phase, what we do is we work with our clients via the course of 4 steps to start out with determining what our clients have, followed by exploring what and who would want what our clients have. And the third step is to determine the sales options that our clients have for selling their practices. And the fourth step is to discuss the payment options that selling firms have when they're considering to sell their law firms. So let's explore first that first step in the design phase. The first step in the design phase is about determining the value of what a senior attorney-led firm has. What we find is that our clients are often wondering and asking, what is my law firm worth? In the design phase, we explore with our clients, okay, what is it that you have? And what we do in this step of the design phase, is we look at really 5 components of the value of a selling law firm. It starts out first and foremost with looking at the book of business. This is really the primary asset that a selling law firm has, and we explore with our clients, what is that book of business for your law firm comprised of? Who are the clients? Where are the clients? When did you last provide services to your legacy clients? And it's not only your clients, it's also your referral sources that comprises that book of business. Next is we explore with our clients, what is the practice areas that you have in terms of volume by number of clients, right? You may offer a number of different practice areas for your firm, and we explore which of those practice areas are the most popular in terms of the clients that are with your firm. So let's just say your firm does trust and estates, business law, and real estate law, and does a little bit of family law as well. We really want to determine, okay, where are the clients coming into? What are your primary practice areas? Next is, what's the revenue by practice area? Because you may have a large volume of clients in a certain part of the practice, but where does the money come in from those given practice areas? So we're exploring that with our clients as well. That is, where is the money in terms of the practice areas that your clients retain you for? Next is, we want to look at a different form of asset that your law firm has, which is your key lawyers and support staff. These are very important values of your law firm. For sure, the book of business is very important. The money that comes into the practice, very important. Question that a buyer has is, who's going to continue to do the work? And that's why we really need to explore the value of your key lawyers and your para staff. Who are they? What do they do? How long have they been with you? What are their billing rates? What are the benefits that you pay to them? Really do a very deep dive in terms of that. What do you have, by exploring your key lawyers and your para staff. And then lastly is, what are your digital marketing analytics? More and more, we're now in the mid-2020s. We're heading towards the 2030s. Growing law firms, which are the primary purchasers of law firms, they want to know how you are performing digitally. What are your Google Analytics? What are your SEO rankings? How many clients are contacting your firm via contact forms on your website? How many 5-star Google reviews do you have? We explore that question, or those questions about your digital marketing analytics, all as part of that first step of the design phase to determine what it is that you have. The next step in the design phase. And the next step in the design phase is analyzing who wants and needs what a selling law firm has. And what we've learned over the years is there's really two primary purchasers. And really, of the primary, we'll discuss in just a moment. One is your typical purchaser, and the second one is what we call your infrequent purchaser. Your typical purchaser of a law firm who wants and needs what a senior attorney senior attorney-led law firm has is a growing law firm. A growing law firm wants and needs what senior attorney law firms have because senior attorney law firms offer three resources that boost the growth for growing law firms. And those three resources are your book of business that offers instant client growth to a growing law firm. Second is your experienced workforce, your key employee lawyers, and your parastaff. And the third is the digital content that your subject matter knowledge presents. That is, your firm may not have the time, and we find this often with senior attorney-led firms. They may not have the time to be doing multi-channel digital marketing, to be leading podcasts, to be publishing YouTube videos. Growing law firms, on the other hand, they recognize that to grab the attention, to get the attention of today's and tomorrow's clients, they need to be publishing digital content really on a daily basis. And that third resource that senior attorney-led firms provide to growing law firms is the ability to convert literally treasure chests of subject matter knowledge into digital content. Now, in terms of the infrequent purchasers of senior attorney-led firms are your key employee lawyers. Sorry to break that news to you, and we do have to break that news to our clients who typically, when we start the design phase, they really want their internal successor, that key employee lawyer, to succeed and to purchase their law firm. What we have found and what we explain and really explore, it's possible that your key employee lawyer or lawyers at your firm do want to purchase your firm. What we have found over the years and what we explore in the design phase is that what key employee lawyers, what they really want is three things. They want a reliable, predictable, and safe job as compared to succeeding to owning their boss's small business law firm. That brings us to the next step. Step 3 of the design phase is determining a preferred sale option. So in the first two steps, we determined what it is that you have. And the second step, we addressed who would be interested, who wants and needs what you have. Now, what's a preferred sale option? We explore that in the design phase. Is really 4 options that we explore with our clients. That preferred option is to join, sell, merge with a growing law firm because growing law firms want and need what you have. That client list of yours, your experienced workforce, and the ability to convert your subject matter knowledge into digital content. The potential option that we explore is structure an internal sale. And there we're discussing with our clients, do your internal successors, your key employee lawyers, do they really want to purchase your law firm? Can they afford to purchase your law firm? Or do they really only want a reliable, predictable, and safe job? The third option is to maintain the status quo. That's a risky option. Some lawyers, some law firms prefer it. Maybe you're just not ready to sell your practice yet. We explore in the design phase, though, that if you maintain your status quo, and if you assume that today is going to be like tomorrow, and that tomorrow is going to be like today, the risk in maintaining the status quo is that a random Tuesday event could happen. And unfortunately, we see it often. We're getting calls from lawyers after a random Tuesday event happens. The most typical random Tuesday event is that when your key employee lawyer or lawyers, when they leave your practice. You've employed them, you've paid them, you've given them bonuses, great benefits for years, and they walk down the hall one day on a random Tuesday and give you 2 or at most 4 weeks notice. And that can happen when senior attorney-led firms are maintaining their status quo, because when a key employee lawyer leaves, not only are you missing out on who you thought was going to be your internal successor, now you're going to be struggling to hire a replacement to do the sophisticated work of your key employee lawyer, to provide the billings that the key employee lawyer offered, and also then to be thinking about, all right, now how can I sell my practice if I'm not billing as much because the key employee lawyer left with and potentially left with clients as well. Another form of a random Tuesday event, unfortunately, is when a senior attorney founder of a law firm becomes disabled or passes away. And in those situations, unfortunately, the value of the practice just plummets. And then there's a fourth option, what we call the alternative to a sale. And this is sort of an add-on in some respects to status quo. That is, in the design phase, we're exploring with our clients, okay, I'm not ready to sell, but I do want to slow down. What's an alternative? And there, an alternative to a sale is to become a referring attorney. Too few lawyers benefit from Rule 1.5 of the Rules of Professional Responsibility. We're often familiar with Rule 1.5 in the context of personal injury law, when we're making a referral to a personal injury law attorney in consideration for, let's say, a 1/3 referral fee. Well, Rule 1.5 in every single state, and has its own version, permits lawyers to refer matters to another law firm in consideration for a referral fee, provided that the client is aware that the consideration is being paid from the law firm receiving the referral to this, let's say here, senior attorney that's making the referral. So for those senior attorneys that are generating business and are not ready to retire just yet or sell their practices, relying upon utilizing Rule 1.5 and becoming a referring attorney is a way to have an additional option for selling. And I'll put air quotes around selling, because you're not necessarily selling yet, but you are certainly benefiting from the value of your practice by making referrals and getting paid referral fees via Rule 1.5. And next is step 4. In step 4 of the design phase, we're addressing with our clients the payment options, right? That is, we now determine what it is that you have. We have explored who wants to purchase what it is that you have. We've decided among the options that you have, what's your preferred option. And what we find often, the preferred option is to sell your practice, merge your practice with a growing law firm. Now the question is, all right, how are you going to get paid? And here we share with our clients is really 3 options in terms of how buyers of law firms are paying selling firms. Most often, what we continue to see with senior attorney-led firms is what we call law firm sales 1.0. And law firm sales 1.0, a growing law firm as the purchaser, is agreeing to pay a selling lawyer or law firm on an earn-out basis. That earn-out basis is fee sharing that is derived from the collections attributable to a defined client list and referral source list of a selling law firm. Said a different way, it is the earnout based upon the performance of the book of business of a selling law firm. Why is law firm sales 1.0 so popular? Because of the goodwill nature of a selling attorney or law firm. A buyer, and certainly a bank, is not sure whether the clients are going to continue with the purchasing firm. As a result, purchasing firm's value proposition is, okay, if you transition, you as the selling firm or lawyer, you transition your book of business to our firm, you continue to practice, let's say, of counsel to transition those clients, what we call trust transfer. Transfer the trust of your clients and referral sources to us, the growing law firm. We will pay you as consideration a percentage of the revenues derived from that book of business. And we're often seeing somewhere in the neighborhood, outside of contingency fee practices, somewhere in the neighborhood of 20 to 30% of the collections of the fees from the book of business paid over the course of, let's say, 5 years. Said differently, that what we're generating and seeing for our clients and discussing with them in the design phase is an expectation for somewhere in the neighborhood of a 1 times gross revenues as the consideration for your law firm via law firm sales 1.0 as an earnout. Then there's law firm sales 2.0. As we're heading closer to 2030, we are starting to see law firm sales 2.0. And the distinction between law firm sales 2.0 and 1.0 is the addition of digital value and brand equity. Post 2020, law firms are generating more and more business digitally. As a result of generating business digitally and law firms becoming digital rainmakers, as compared to yesteryear's word of mouth rainmakers, a digital rainmaker based upon the digital value and the brand equity that your firm develops is generating business not because of a singular attorney or attorneys. As a result, a bank is willing to finance on law firm sales 2.0. A law firm buyer is ready to believe the supporting evidence of the Google Analytics and other forms of data analytics that are coming in, showing how cases come in without the need of the personal goodwill, or really supplementing the personal goodwill of a selling attorney or attorneys. So in Law Firm Sales 2.0, what we are seeing is the introduction of a fixed price based upon that digital value and brand equity, plus earn-out payment terms. And then there's a third option. Well, really, there's several options in terms of additional payment options. It's really three that we see in the marketplace and that we discuss with our clients in the design phase. First is there could be a fixed price. We see fixed pricing mostly on internal sales. When there's a senior attorney selling to one or more key employee lawyers, they know the practice intimately, that is the buyers, and the sellers are comfortable entering into a fixed price promissory note. Often, though, what we're seeing with fixed price sales on an internal sale is less than a 1x of gross revenues that our clients are seeing in the marketplace when they are selling to a growing law firm. Second option among these additional payment options is a buy-sell agreement. Maybe you're not ready to retire yet, and maybe you're not ready to sell yet, but you really would like to go to bed at night knowing that your internal key employees could take over your practice if a random Tuesday event happened where you become disabled or you pass away, or you strike a deal with a colleague of yours under a buy-sell type agreement. That is, it's triggered by a certain event buy-sell agreement. And then the third option of the additional payment options is a tiered purchase. And we're also seeing this mostly with internal sales, where it's not 100% of the stock, the ownership of the firm in one clean swoop. It's a tiered purchase over time by an internal key employee or employees. So in sum, in the design phase, our goal and our modus operandi with our clients is to explore what it is that you have, and also explain to our clients who it is that wants what it is that you have. And then we determine what is your preferred payment option, and then also explore what types of payments as consideration for your law firm that you can expect in the next phase of what we do with our clients, which is to broker the sale of our clients' law firms after we have finished the design phase. Okay, so for our next question today. Our next question is, could you tell us about your background and why you founded Senior Attorney Match? Sure, thank you. So my name is Jeremy Poock, and I founded Senior Attorney Match in 2013. I practiced law for about 13 years beforehand, passed the Massachusetts bar in the year 2000. Still think that I passed it because I have terrible handwriting. As a lawyer, I migrated towards working with business brokers. I probably should have gone stage left to business school rather than go to law school. And by working with business brokers, I helped them to paper their deals when they were selling all types of what I call Main Street businesses, mostly businesses that have gross revenues of under $5 million. At that time, in the early 2000s, it was already clear that the business brokers were focusing on baby boomers, recognizing that baby boomers present the greatest wealth transition that is going to happen in probably all of history. And they were already focusing on baby boomer sellers of almost every business, except, as I started to observe, law firms. And so as an entrepreneur, started thinking to myself, okay, there are baby boomer attorneys, there are senior attorneys and other attorneys that want to sell their law firms. And could I help as a business person, as a lawyer, help to facilitate the sales of law firms? And that was really the genesis of the creation of Senior Attorney Match. And as we explore that more, we really started to think about, okay, what are the options that a selling lawyer or law firm has when it comes to selling their law firms? And what we've learned over the years is that selling law firms really have three options when it comes to selling their firms. There is what we call the preferred option, is a sale to a growing law firm, because what we consistently see in the marketplace is that growing law firms want and need what senior attorney-led firms have. They want and need their books of business, their staff, and their subject matter knowledge. The second option is what we've learned over time is the potential option. It's to structure an internal succession plan. We've learned that that's really only a potential option because all too often your would-be internal successor is really just a key employee. You hire them to do the work where you, the owner of the law firm, were generating significant amounts of work. So you hired a key employee lawyer or lawyers. And when you now are thinking that, okay, can they take over my practice? What is it that they wanted then? And what is it that they want now? They really wanted then and now a reliable, predictable, and safe job as compared to being an entrepreneur and overseeing and running and succeeding to a senior attorney's small business law firm. And then what we see is the risky option. And that risky option is to maintain the status quo, which is thinking that if today is going to be like yesterday and tomorrow is going to be like today, then I really shouldn't make any changes. And what we've seen over the years is that when senior attorneys, when they stay in their status quo for too long, a random Tuesday event can happen, which can cause the value of their law firms to plummet. Because if a senior attorney is not available, let's say in a situation where a senior attorney could predecease or become disabled, then the practice value just plummets. And the next question that we are receiving all the time is, okay, what's my law practice worth? And here, what we've developed over the years is to recognize that law firms really have 5 components of value. Those value chips, as we call them, they're comprised of a client list and the referral source. That's the book of business that you've worked so hard to develop over the course of your careers. The 3 additional value chips are the goodwill that you've developed in your locality, your state, your region, sometimes nationally, sometimes even internationally. The subject matter knowledge that lawyers at a law firm have developed in a particular number of practice areas. And more, what we're seeing in the marketplace is a development of digital value and brand equity. And so when we're thinking about for our clients and the value that we can offer at Senior Attorney Match of determining what value do you have in your practice and who would want to purchase your practice, what we consistently see is that it is growing law firms. It is growing law firms that want and need what senior attorney-led firms have. Growing law firms want and need your clients, that is your book of business. They want and need your key employee lawyers and your parastaff. Your same key employee lawyers who do not want to purchase your law firm because they can't afford to, they don't want to, and they want a reliable, predictable, and safe job are lawyers that growing law firms want and need to continue to working on the clients of your book of business. That is, if you're selling your practice to a growing law firm, that growing law firm has a query of who's going to continue to represent the clients. And when you're presenting an experienced workforce in terms of key employee lawyers and support staff, music to the ears of growing law firms. And growing law firms, they also want and need your subject matter knowledge to convert that subject matter knowledge into digital content to attract the attention of today's and tomorrow's clients that continue to look online when they're searching for lawyers and law firms to hire. And when it comes to why when it comes to why leading Senior Attorney Match is just so satisfactory in terms of meeting the needs of my own, I love connecting people and connecting businesses with each other. And when the matches happen with Senior Attorney Match, what we see is 4 winners. And those 4 winners, the 4 winners that result after senior attorneys sell their law firms to growing law firms are first, that the senior attorney, him or herself, is able to monetize their practice. They're able to start practicing less. They're often staying on as of counsel attorneys, but they are practicing less, spending more time with their families, and are finally relieved that they are no longer having to run the office. The second winner is the key employee lawyers and parastaff at your firms. Your key employee lawyers, by and large, they want a reliable, predictable, and safe job, and so does your para staff. And when you merge or sell your practice to a growing law firm, it is a huge win for those key employee lawyers and para staff. The third winner is the clients, right? You've represented clients for years, sometimes even decades. And when senior attorneys sell their practices to growing law firms, they can rest assured that their clients are in capable hands to receive continuing, competent, and zealous representation by the lawyers at a growing firm. And the last winner is the growing law firm itself. Growing law firms, what are they always looking to do? They always need and want new clients. They win big time by succeeding to purchasing, merging with a senior attorney-led firm, by inheriting, succeeding to the book of business. Secondly, they're welcoming in talented, experienced key employee lawyers and support staff. And thirdly, they win by being able to have access to the subject matter knowledge that senior attorneys and additional attorneys at senior attorney-led firms have developed to convert that subject matter knowledge into digital content to support their multi-channel digital marketing that they recognize that they need to continue to deploy today to attract the attention of today's clients. Okay, so for today's guest appearance, very excited to introduce attorney Greg Maxwell. Greg joins us from Amicus Settlement Planners. We handle a significant number of law firm sales for contingency fee practices. And in contingency fee practices, which are typically plaintiff side personal injury law firm practices, the payouts are typically earnouts. And Greg leads a company and is part of a company at Amicus Settlement Planners, where we're going to explore the following question today, which is, what tax savings value do structured settlements provide to sellers and buyers of contingency fee law firms? So Greg, before we address that question, love for you to introduce yourself, and thanks so much for joining.
Yeah, no, thank you, Jeremy. Appreciate the opportunity to be here. So our company is called Amicus Settlement Planners. We primarily work with contingency fee-based practices. So that means mostly, plaintiff attorneys. Most of those, about half of those are personal injury, about half are employment, plaintiff employment law firms. And so we do a lot of tax planning for those clients, for those, especially on the employment side, that are receiving taxable damage cases, help them plan for settlement, help them spread out the recovery to reduce the tax bite that they encounter when they receive these settlements. And then we do work with business owners that are selling, and increasingly, law firms like you mentioned, who are trying to sell but don't want to take the tax hit in the year of sale. So there are some things that we can talk about that we'll get into that help with the tax planning.
Terrific. So let me just share with our audience, okay, just a typical sale of a senior attorney-led personal injury law firm. In those sales, you'll see really two flavors for the most part. One is a pure earnout. Okay, that is that selling lawyer of a personal injury law firm presents his practice or her practice to growing PI firm. Growing PI firm then says, okay, we will pay you a portion of the revenues that come in from the clients that are attributable to your firm. So past clients that make referrals come in from your website, your phone number, your referral sources will treat you as a referring attorney, let's say for 5 years. Second flavor is really an add-on to that, which is, okay, we will pay you the earnout basis and we'll pay you an upfront amount. And that upfront amount is typically an advance on accounts receivables based upon the number of open cases that a seller may have at a given time. And so it's good in terms of being able to monetize. In terms of what you were talking about, we'd love to hear more now, is it opens up the seller to significant regular income tax issues.
Absolutely. Yeah. So in the situation you mentioned where there's going to be an earnout, but in the year of sale, there's going to be an initial payout to the seller. That's really where we can come in and really help the seller with their tax issues. So rather than, if we use an example of, say, they're going to get a couple $1 million up front, and then the rest of their compensation is going to be coming down the road as the firm continues to earn money. If the seller doesn't necessarily want to receive all of that $2 million in the current tax year and be taxed at the highest tax rates because of that, we can enter into what we call a structured installment sale, where the buyer, as part of the purchase and sale agreement, agrees to pay whatever portion of that $2 million. Let's say it's 1.5 million of the 2 million. That's part of the upfront fee. They send that, the buyer would send that directly to a company like MetLife or Independent Life. Those are the two main companies that offer these types of arrangements. And then the seller can then come up with a future series of payments. It could be the next 3 years, 5 years, 10 years, the rest of their life, that they receive the payments from that initial portion. So the point of that is to really get them down into the tax bracket that they want to be in, so that they don't have a huge spike in taxes the year they sell their firm, and then the next years they're back down where they want to be. Excuse me. This gives them the opportunity to spread out that recovery, guarantee themselves some income, and keep themselves in a tax bracket that's more comfortable for them.
Terrific. So let's just drill down a little bit more on that, because I think a lot of the personal injury law attorneys are familiar with, okay, if there was a case that settled for $6 million, okay, and resulted in a $2 million fee, right? And then enter into a structured settlement like we're talking about here. What we're talking about in the sales context, which I think is just so fascinating, right, is that if there was that advance on the accounts receivables, or even let's just say it was an upfront payment based upon the brand value of the firm, okay, that the $2 million is paid. Can you just explain? I remember in my tax class, Greg, the 3 T's in taxes: timing, timing, and timing. That if we could just explain that a little bit more on that $1.5 million, like what are we doing with that money that's benefiting the seller when the money would otherwise hit them and they'd be paying significant taxes on it?
Right. So rather than the seller taking that $2 million in the current tax year and being taxed on it, if you structure it the right way and you have it as part of the purchase and sales agreement, then what's happening is the buyer is agreeing to pay the $2 million, and they're agreeing to make future periodic payments to the seller. But then they're assigning the obligation to make those future periodic payments to MetLife or Independent Life. So the buyer is not on the hook for those future periodic payments. They're assigning that obligation to MetLife. And then what the seller receives is an annuity contract from MetLife, for example, that guarantees them those future payments. So they're only taxed on those future payments as they receive them back from MetLife in this example. So they're not taxed on that full $2 million amount in the year of sale.
Terrific. And now, if it's okay, we'll work through a hypo. Okay. So this is an example of something that we see in the marketplace. Let's say, for example, that a 67-year-old owner of a personal injury law firm is regularly bringing into the firm $2 million in legal fees. Okay, strikes a deal with a buyer, and the buyer says, okay, we're not going to pay you anything up front. We will treat you as a referring attorney for this hypothetical. Let's say they're all direct cases. Okay, there's no referring attorneys involved. They're direct cases, which, by the way, would be great. And the deal that the buyer strikes, we're going to pay you a third of the $2 million, assuming that your book continues to perform. And let's say it does. So for 5 years, the buying firm would be paying 1/3 of $2 million. That'd be $667,000 a year that the seller would be getting for 5 years. But seller tells you, Greg, okay, that our family only needs $350,000 a year because I'm 67. I've got other retirement income coming to me and investment income, who knows what. They only need $350 out of the $667. So what say you?
Yeah. So in that situation, what we'd probably do is set up a deferred comp plan with a plan administrator that works with contingency fee-based attorneys. And so what you could essentially do is say, all right, once the law firm hits that or once they've paid out enough to get to that $350,000 mark that the selling attorney wants every year, then anything above that, rather than paying it to the selling attorney directly, they're going to send it to the deferred comp plan administrator. And then that's in the name of the seller. So that way, that 317, I think that's the right math, that would otherwise go to the seller, would go directly to the deferred comp plan in the name of the seller with the plan administrator. And in the same way as the annuity, they're not taxed on that 317 until they receive it back from the plan administrator in the future. So,
great. And I think the overall message, right, is that whereas buyer is prepared to pay a third of a third, which is great, if the seller is able to defer the taxes on $317,000 in our example over the course of 5 years, right? Let's do the math, $1.5 million in deferred taxes. And if you could just share with us a bit about the beneficiary aspect of this as well, because 67 years old, you never know, God forbid, the lawyer could pass away, right? Mm-hmm. There's a beneficiary aspect to all of this as compared to just getting that money as it's coming in.
Right. So whether it's an annuity or with this deferred comp plan administrator, the selling attorney would name a beneficiary. So if they happen to pass away within the term of the payback, they would just go to whoever they name as beneficiary. So yeah, that's not a problem.
Terrific. Well, Greg, thank you so much for plaintiff side personal injury law attorneys. Mm-hmm. Structured settlements are not known well enough yet when it comes to succession planning for your practices. Greg, thank you so much. How can people get in touch with you, Greg, if they've got questions about structured settlement planning?
Yeah, no, I appreciate it. You can reach out to us online. Our website is amicusplanners.com, or my last name, Maxwell, at amicusplanners.com. But yeah, happy to chat with you about any of these options, because it can be really, like you say, really powerful tax planning for the selling attorney. And then also, most attorneys like the thought of receiving future payments from a company like MetLife rather than relying on, how the buyers of their firm perform. So it gives them a little comfort that way. So yeah, absolutely. Thanks, Jeremy. I appreciate it.
Wonderful. Thank you so much.
All right. Take care.
Okay. So for today's Poock's Post. Today's Poock's Post is why the clock has begun ticking on law firm sales 1.0. So let's first put a definition on law firm sales 1.0. Law firm sales 1.0, which is the primary sale vehicle that we see and have seen throughout the 2020s, involves an earnout price where selling law firm is selling their book of business, that is their client list and the referral source list, to a growing law firm in consideration for earnout terms. And that book of business, let's look at how did most selling law firms develop their books of business over time. Most selling law firms, baby boomer-led firms in particular, they built their books of business pre-Google. They did it what we call the hard way, right? Like, you remember all of those networking events that you went to. You went through hundreds, maybe even thousands of business cards per year of in-person networking. You gave CLEs, in-person CLEs. You wrote articles. You placed ads in ad books for all types of local charities, let alone attending charity dinners. And you placed ads old school in places like the White Pages, the Yellow Pages, newspapers, journals, and TV and radio, and built up that book of business. But, and here's the but, in 2020, and really it started with Google, clients, they changed, right? Rather than clients asking via word of mouth, who do you know? Who do you recommend as the best fill in the blank attorney for a particular client's need? Clients have begun and will only continue to look online via Google, via social media, via ChatGPT and other forms of AI for best attorney for fill in the blank needs. And as a result, senior attorneys in particular are on notice that digital marketing disruption has arrived to the legal industry. And just as a question, if people are going to push back on that digital disruption with regard to business development, when was the last time that you reordered 500 new business cards because you've given them out as part of your business development efforts? Now, here's good news. The good news is that for growing law firms today, okay, what they are recognizing is that to develop business in the post 2020 era, they need to do so digitally. So for those law firms that get it in terms of digital marketing, they're recognizing that they need to have a Google strategy in terms of making sure that you are coming up first page in the 3-pack on Google. They are publishing to multiple channels of digital marketing, of social media platforms, because when clients today are looking online, they want that social proof. They want to see and hear from lawyers and law firms. They are progressing with and adding to their websites, making sure their websites are update, interactive, providing means and ways for today's, tomorrow's clients to communicate with lawyers and law firms, texting, submitting forms and whatnot. They are publishing podcasts as well as videos to set themselves apart as authority figures. You don't today just need to have an article written in your local law journal. You can be publishing your own YouTube channel on the subject matter knowledge that you've developed in your given practice area, or lead a podcast or join podcasts. And then, of course, there is the old school way of continuing with in-person type networking. In terms of growing law firms, what is it that growing law firms want and need? Yes, growing law firms, they are deploying multi-channel digital marketing to attract clients to their firms. But what do they really need to boost growth? They need new clients. They need experienced lawyers and parastaff to do the sophisticated work that their law firms continue generating. And they need a continuous access to subject matter knowledge that they can convert into digital content for the digital marketing needed to attract today's and tomorrow's clients to their law firms. Here's the but, though, when it comes to senior attorney-led firms. When it comes to the major value chips for any law firm, the two primary value chips of a law firm when it comes to considering selling your law firm, and why we are at the point where Law Firm Sales 1.0 is coming towards its end, is because those value chips primarily need to be filled with clients that comprise your client list, and referral sources for your referral source list that combined makes up your book of business. If a senior attorney-led firm is not generating new clients digitally, and if the referral sources of the firm are not being replenished because those referral sources are often similarly aged as senior attorneys and they're starting to retire, move away, God forbid, pass away, then the value of senior attorney-led firms is going to get less because the book of business is not replenishing as much as it did in yesteryear. So now let's look at that impact on Law Firm Sales 1.0. If your law firm is not replenishing its book of business as often and as well as it did during the pre-Google word of mouth era, because you're not investing in digital marketing, multi-channel digital marketing, then your law firm is going to become less valuable, because if you have less clients, less referral sources, then a purchaser who's typically going to be buying your practice based upon an earn-out basis, based upon the revenues derived from your book of business, if your book of business is diminishing in size, then the value of your practice is going to get lower and lower as time goes by. So here is the continuing good news, though, for senior attorney-led firms. For now, you're presenting clients and referral sources to growing law firms. That's the primary asset, the primary boost for growth that growing law firms want and need is your book of business. They also want and need your talented lawyers and support staff, and they want to convert your subject matter knowledge into digital content. However, I'm just going to share a couple of things that we're starting to see in the marketplace. Some growing law firms are saying no thanks, even to a book of business that a senior attorney-led firm offers. Why? Because they can generate the clients themselves via digital marketing. And it can be for less money, right? Why would they do that? Because it could actually be for less money than paying out on the earnout basis, the fee sharing on an earnout basis. They're also attracting, that is growing law firms. They're attracting more talent than your talent may very well provide. And the talent in your firm, if they're not prepared to make changes, then growing law firms are sometimes not wanting your talented lawyers and support staff because they may very well buck the system of the systems and processes that growing law firms are starting to introduce. So as we head towards 2030, what we are seeing is that the clock has begun ticking on law firm sales 1.0, primarily because growing law firms are starting to generate enough clients digitally. So if your law firm is not generating as many clients as yesteryear, and we recognize that the clock has begun to tick on law firm sales 1.0, we are highly recommending in the mid-2020s and as we head towards 2030 that senior attorney-led firms in particular, this is the best time to derive value from your law firm when it has clients, experienced, talented lawyers and support staff, and subject matter knowledge that growing law firms want and need to convert into digital content. And that is episode 27 of the Ask the Law Firm Seller Show.